pre-trial proceedings. Just like the name implies, it means the proceeding that is conducted before the main trial. Both of them are proceedings. But there is a proceeding that takes place before the trial proper. What happens at the trial proper is determined by what happens at the pre-trial proceedings. Because some of the times after pre-trial, main trial may not be necessary again. Some proceedings terminate at pre-trial proceeding stage. And that's one of the major reasons for the drafters of the law to bring about these pre-trial proceedings. Now, we have noticed that if after pre-trial proceeding, there is still need for a proper or major trial, the major trial will go ahead. But the major trial is made less cumbersome because the pre-trial proceeding has in the main reduced the workload of the trial judge. So that's one of the importance of pre-trial proceedings. And then what is done? That's the question. Why pre-trial proceedings? What are the things done at pre-trial proceedings? First of all, we want to look at the major purpose of pre-trial proceeding. The major purpose of pre-trial proceeding is one, to dispose of all non-contentious matters. To dispose of all non-contentious matters which are capable of being dealt with at interlocutory stage. Which are capable of being dealt with at interlocutory stage. This is one of the major reasons. Secondly, to enable the court to give such direction, that may help in expeditious determination of the matter. To enable the court to give such directions that may help in disposing the matter expeditiously. Thirdly, to create an avenue for possible amicable settlement of the case, not settlement out of court. To create an avenue for possible, I use the word possible because it is not mandatory, for possible amicable settlement of the case. Under this heading, that's talking about this amicable settlement of the case. Under this heading, parties may be referred to an arbitration. Pre-trial proceeding is also known as conference and scheduling. It is called conference in the sense that both parties interact with the judge. Both parties interact with the trial judge to come up with measures for smooth trial and expeditious disposal of the matter. So that's why it is called conference. Scheduling comes in when the parties on their own narrow the issues for determination. Scheduling comes in when the parties on their own narrow down the issues for determination, in which case the trial judge will give direction as to the hearing of the matter. Some of those directions include, but not limited to the following. Such directions include, but not limited to the following: determination of number of witnesses, taking into consideration the list of witnesses filed by both parties. 2, The trial judge may at this stage admit documents that are non-contentious. Admit documents that are non-contentious. And thirdly, the trial judge may apportion dates within which each party is to present his case and call his witnesses. Within which each party is to present his case and call his witnesses. So what I'm saying in that regard is that a judge may decide to give the claimant 4 days. Use 4 days, prove your case, call whoever you want to call, and then after that, give another 4 days to the defendant. It's possible that at the scheduling period, the mind of the judge is set. The judge is looking at the period of time within which this matter will commence and end. So the judge will even at scheduling stage give counsel date for written address, final written address, and may also foresee a possible date for judgment, subject to any other inconveniences. That's why it is called scheduling. That's why it is called scheduling. And then we'll move on to the next stage. When is it right to commence pre-trial? Pre-trial is supposed to be commenced at the instance of the claimant. Pre-trial is supposed to be commenced at the instance of the claimant 14 days after close of pleadings. 14 days after close of pleadings. In which case the claimant is to apply. In which case the claimant is to apply to the court for pre-trial proceedings in terms of forms 17 and 18 of the schedule to the rules of Abia High Court Civil Procedure, Practice and Procedure Rules 2021. Because that is our anchor point for now. When you get to law school, they'll be talking about Abuja and Lagos. Those are neutral places because they can't be talking of everybody's and discover that the provisions are mutatis mutandis, they're the same. Right. So the only thing you're going to move there is move the provisions if they are not the same. So once pleadings are closed, 14 days thereafter, the claimant will be under obligation to apply to the court for pre-trial proceedings. And the manner of making that application is neither by motion of notice nor by a letter, but by the forms specified as Form 17 and 18 to the schedule of the rules of court. So when I say rules of court, I believe you know I'm referring to Abia State rules. 17 and 18. So I may just take a little bit time to give you the contents, briefly, the contents of Form 17. Form 17 is headed, first of all, you write Form 17, you write the title, Pre-Trial Proceedings. Pre-Trial Proceedings, in bracket, Order 25, Rule 1, Sub Rule 1. Order 25, Rule 1, Sub Rule 1. Then, you now write the heading of the court. In the High Court of Abia State of Nigeria, in the High Court of Umuahia Judicial Division, holding at Umuahia, by your right hand suit number at least, you put the suit number, then come down to your left extreme, you write between, and then the names of the party, A, B, C, D, versus, you just write and. So we, in civil, we say against, we don't say versus. Versus is only used in criminal proceedings. You just write A, B, C, D, and that and means against X, Y, Z. Plaintiff, claimant, defendant. And then, just like the way you address your writ of summons to, you now bring down the name of the defendant because you are addressing the defendant. You put the name of the defendant, simply say, take notice that you are required to attend court on so dash day. The registrar will fill in the dates at 9 o'clock in the forenoon or so soon thereafter. for a pre-trial conference for the purposes set out hereunder. Those purposes are the purposes I've already discussed. One, disposal of non-contentious matters, so on and so forth. And then subparagraph 2 says, please answer the questions in the attached pre-information sheet. That's in Form 18. So Form 18 is going to be questions. So I'm going to talk about that. And then after that, there's also a note of caution that ends it, which says, take notice that if you do not attend in person or by a legal practitioner at the time and place mentioned, such proceeding will be taken and such order will be made as the judge may deem just and expedient, and then you end. So I'm going to talk about later what will happen if a party fails to attend. Now from 18 has the same heading. And then the first paragraph simply says, this pre-trial information sheet is intended to include references to all applications which the parties will wish to make at the pre-trial conference. Applications not covered by the standard questions raised in this part of information sheet should be entered under item 12 below. In other words, this is a prototype questions. If you feel there are some other questions you need to add, you feel free to do that under what? Paragraph 12 or clause 12. And now some of those questions are just like, do you require the action to be consolidated with any other one? If there is any other action that is pending, maybe a sister action, you simply say, well, yes, if you want them consolidated. But if this is a fresh action, there's no other action, definitely there's nothing to consolidate. You simply write what? No in your answer. The first page is question, the other page is answer. Now, 2, are amendments to any originating or other processes required? Maybe at the time that you are filling this form, there is no need for it. You will simply say, in the course of the trial, or not for now. Right. Number 3, are further and better particulars of any pleading required? If so, specify what particular. You can also say, not for now. Why not for now is that at that very stage, you have filed your reply as a claimant, and there is no issue whatsoever. But at the trial, there may be need, or at the pre-trial proceeding itself, there may be need for you to require what? Further and better particulars. Further and better particulars, maybe somebody has tendered a document during pre-trial, and you do not quite understand the relevance of it, or how it has affected your matter. You may demand that party furnishes you with a further and better particulars of that. In other words, give me more information so that I can exercise my right to fair hearing and respond to you accordingly. So that's what that question is all about. 4, do you object to any interrogatories that may have been delivered pursuant to this? You say none yet, because none has been delivered to you. But if any has been delivered to you, you may say yes or no, but naturally you don't say no. Because when interrogatories are exchanged or forwarded to you, you must do what? You must respond to them. And mind you that in certain things under the law, when you remain silent over certain things, it's taken as what? Admission. All right. 5, do you object to produce any document in respect of which a request has been covered? No. If you intend to make any additional admissions, give details. Most likely, you are not going to make any admission against your own interest. You simply say no. 7, will interpreters be required? If you're going to bring maybe a witness who is not proficient in English language, both in hearing and speaking, you may say yes, right. And some times, you see a graduate will come to court and they like to speak in vernacular. There's nothing shameful about it. Do you understand? He simply wants to make sure that, there are people who are, let me tell you, out there, people are scared of lawyers. If they feel that your English is there to bamboozle them, they will say, I will speak in Igbo. So that by the time you interpret it in Igbo, I understand it properly and respond in Igbo. then you translate. So that all those big English, we first of all hit the interpreter before getting to me. So that's so the interpreter now becomes your shock absorber. All right, 8. Is this case in which the use of a single or joint expert witness is allowed if you feel you have need for an expert evidence, expert witness? You also do what? You state. And then state in the material fact whether you need a single one or more than a single expert witness. Let's say, for instance, you need an expert forensic witness in handwriting, maybe also some printing, and then you may also need an expert in culture. Right. Mind you that expertise doesn't mean that everything about expertise is something you're taught in school. You understand? It's your area of calling. You know, a musician is an expert in that very area. You understand? A keyboardist is also what? An expert in that very area. 9. Is there any way in which the court can assist the parties to resolve the dispute? This is where ADR is like coming in. If, for instance, you still believe that peace is still feasible, you say yes. So that in the end, during the scheduling, my Lord will say, okay, let's handle this first. You may want to say, parties see me in chambers and find out what actually the matter is and whether it's something my Lord can resolve. 10. Have you considered some of the alternative dispute method, ADR, blah, blah, blah? You can say yes, maybe you have gone to your traditional counsel, and the other man refused to submit. Of course, under the law, he is not bound to submit to customary arbitration. But once he submits, he is what? He is bound by the decision. State any question or questions of law arising in your case. This is basically for lawyers, issues for determination. And I have on a number of occasions spoken to different fora of the bar on how to couch this. Most of the times it is difficult at this stage for you to couch an issue for determination because trial has not begun. You have not even done cross-examination because during cross-examination you may end up contradicting, gaining through contradiction. And when you have gained from contradiction, the issues now become narrow. You now discover that some issues may come up which we never foresaw at this very pre-trial stage. So what we normally do is maybe to do an omnibus issue for determination, whether the claimant has proved his case. Of course, you can't even say, properly speaking, whether the claimant has proved his case because it has not been heard. Do you understand? So, at times, when you look at the pleading of the opponent, you see that the opponent has not admitted anything. Or you may even couch it whether by evidence that may be adduced in this matter, the issue of title could be resolved in favor of the claimant. That sounds better because it's still a probability, right? And then finally, you list the applications you wish to make at the pre-trial conference. Possibly at this stage of pre-trial conference, you've already filed some motion, maybe motion for injunction. You don't want them to enter into the land again, But if maybe at this stage there is no motion, you can simply say, my Lord, there is no motion. Right. So we'll move over to the next part of this pre-trial study. Then some of the applications that may be taken at this stage include, but not limited to, the following. 1, application for joinder of parties may be taken at this stage. Application for joinder of parties. Application to amend any of the processes already filed may be taken at this stage. And then nothing stops a party at a trial here from indicating intention to bring a motion. He said, my Lord, I still want to file a motion. And then your application will be noted, but you make sure that your motion is filed within the period allowed for pre-trial and determined accordingly. This is because pretrial proceedings does not last for one day. But in practice, you discover that in good number of times, pretrial may start and end that very day. That is to say that that one was fast. Do you understand? But by rules of court, pretrial should not last less than 30 days. And that is what the law means by after the first pretrial day, the matter will be adjourned for further pre-trial. So a trial court should not be so much in a hurry to give judgment on a day any of the parties fail to appear. The proper thing to do is maybe to order that hearing notices be issued and served on the absent parties, so that on the next day my lord will now be sure that these people have been notified that this pretrial proceeding is holding today. Now, when you look at Order 25-3, it talks about some of the things my lord can do, which I have already mentioned. But for the purposes of extrapolation, it says, at the pretrial proceedings, the judge shall consider and make appropriate action with respect to such of the following or aspects of them as may be necessary or desirable. 1, formulation and settlement of issues. So if A has formulated and B has formulated, my lord can reject it. I refer you to the Bar NDA journal. So I edited it, and in that journal, Honorable Justice Chidonwakama discussed how to formulate issues. So find that journal, it's very important, it will help you. Right, so a judge can on his own suo motu formulate issues to be adopted by parties. B, amendments and further and better particulars. So if there's an application for amendment, my lord will do what we hear it. So that's what he's talking about. Admission of facts. My lord can also know that some certain facts have been admitted either by consent or by conduct. Why I told you that some matters can end at what? Pretrial. Afterwards, what is admitted requires no further proof, except they are declaratory in nature. So that one wasn't declaratory. So we ended there, everybody went home. Right. So my lord will take control of the scheduling. I had said, I give you 4 days, this person 4 days. My lord can also examine exhibits at this very stage and can also narrow down the issue. And another thing here is pretrial timetable. It's also the same like I have said. If on the first day, my lord looks at what has been filed, my lord may decide on the first day, consider list of documents, consider list of witnesses. Then on the other day, consider issues for determination. On the next day, consider whether the issues have been narrowed down. And then finally, also consider the possibility of having the matter sorted out amicably. So that is the power of my lord to draw the timetable. And specifically it says, that is Rule 4, Order 25 Rule 4. Pretrial proceedings or series of pretrial proceedings with respect to any case shall be completed within 3 months. I was even talking about 30 days. 3 months of its commencement, unless extended by, why would we even extend? Because 3 months is even more than enough. 3 months is even more than enough. So if my lord can do it in a day, so precious time could be saved, use the other days to do something else. And then again, there is something we don't do in Abia State, which is also in the rules. But others say do it. Abuja, Lagos do it. Like the matter I'm doing in Lagos. After pretrial proceeding, there is something called report. The same thing also takes place in the election petition. Once that is done, after the pretrial, then there is a report. So we look at Rule 5. It says, after a pretrial proceedings or series of pretrial proceedings, the judge shall issue a report. So you apply for it. the judge will issue a report. This report shall guide the subsequent course of the proceedings unless modified at the trial. In other words, the report of the judge means an order of the court. You don't depart from it, except the court itself decides to do what? To depart from it. If at the trial you have said, I'm going to bring 3 witnesses and I will take them serially, on the day you want to bring in a witness, you can't bring number 3. Because you have told my Lord from the report that it's number 1 that you are bringing. If you bring number 3, my Lord can say no. But in the interest of justice, my Lord can do what? Shift ground and allow for the matter to go on. But it's worse when you come on that and say, my Lord, my witnesses are not ready. That's when my Lord will descend heavily on that very party. And my Lord will say, look at your pretrial report. What did we decide? What have we agreed? What is so clause? You know, which means the timetable, the report of my Lord must be followed what? Serially. It must just be respected. And then assuming there is need for my Lord to refer the matter to ADR, then Rule 6 comes into focus. Order 25 Rule 6 says, where a case is deemed suitable for ADR under Order 3 Rule 11, or has by directive been referred to ADR under Order 3M of this order above, the ADR judge shall, in case of recalcitrant parties, consider and give appropriate directives to parties on the filing of statement of the case and other issues. A. The claimant shall file a statement of case, not statement of claim now, but of case, within 14 days. You know, it's all you simply need to, let me explain it. All you say, assuming the matter has been directed to ADR, maybe my Lord looks at it, this is a family matter, go to family court. It's one of the ADR courts, too. You know, or go purely to an ADR multi-door. You go to a multi-door, then you will have 14 days to file your statement of case. Statement of case, you may not bother with all those grammar you put in your statement of claim. Just tell the court what the issue is. You know, just like National Industrial Court is doing. They want to simplify everything. Tell us what the problem is so that we go straight to it. 14 days you file and serve. The other party will also file and serve 14 days. But the problem I have here is that this rule is talking about in case of recalcitrant parties, the court will impose, you don't impose peace. That's the problem I have with this. Your views may be different, but how can you impose peace? Somebody said, I don't want ADR. I want the legal matter to go into adjudication. Let's litigate it and compromise his choice. He has a constitutional right. He has assessed the court pursuant to Section 6 of the Constitution. Why would you compel him to go to an ADR that he is reluctant to submit to? So what the court will do, everything is listed here. And then sanctions. When you look at some of the rules of this court, it said that if the claimant fails to file an application for retrial, the defendant will have 2 options. Either file or apply for dismissal. The defendant, I don't know which defendant who wouldn't want to apply for dismissal. I mean, you have 2 options. And this person has the duty. He has failed to do his duty and you're going to do his duty for him. No. But most of the times, when you look at, maybe depending on how seasoned a lawyer is, I always advise my client, if you are a defendant and a situation like this arises, go ahead and apply. Right. Because if you don't, you will gain the victory. Judgment will be given in your favor. The case will be dismissed. But it will be mere Pyrrhic victory. Do you understand? It's just like Pennywise conflict. Because you're going to come back all over again. If the other party applies for the judgment to be set aside, he could give 1 or 2 reasons why he wasn't able to be in court. And fair hearing entails that within the possible time that this person has come to be heard, do what? Hear him. Even if things fall apart, it is written, and he said, this boy calls you a bad man. The sanction provision here says, Any judgment made under this rule may be set aside upon an application made within 7 days of the judgment or such other period as the judgment, such other period. So even if you don't come within 7 days, you see why I say it's penny white man finish. The other party, when he comes, the judgment is set aside. The application shall be accompanied by an undertaking. Is important. This person who just escaped by whiskers and wants to be given a second chance must also do what? Sign on undertaking to participate, not just to participate, to participate effectively in the subsequent pretrial proceedings.